This clash between Raymart Santiago versus Tulfo paved the way for a landmark ruling pertaining to the issuance of a writ of amparo. Let's take a trip down memory lane and unravel the magnitude of the Supreme Court's ruling. On the morning of May 6, 2012, around 11:40 a.m., Claudine and Raymart, along with their family and friends, arrived at the Terminal 3 airport from a Cebu Pacific flight. They had just come back from a vacation. While waiting for their luggage, they were told that their bags had been offloaded and placed on a different flight. Upset, they went to the Cebu Pacific complaint desk to report the issue. While they were complaining, they noticed a man taking pictures of Claudine using his phone. Raymart approached him and asked what he was doing. Suddenly, the man who turned out to be journalist Tulfo allegedly punched and kicked Raymart, which led Raymart to fight back. When Claudine saw what was happening, she rushed over, but Mon allegedly kicked and pushed her against the counter. Raymart quickly stepped in to protect his wife. Another person, Eduardo Atalano, also joined the fight. Airport security soon arrived, broke up the fight, and brought everyone involved to the airport police department for investigation. A few days after the airport incident, Tulfo's brothers, Rafi, Ben, and Erwin, spoke on their TV show and made harsh comments and threats against Claudine and Raymart. Feeling scared and threatened, Claudine and Raymart filed a petition for a writ of amparo against the Tulfo brothers on May 11, 2012, at the Regional Trial Court, RTC. Later, on May 23, 2012, Erwin Tulfo filed a motion asking the court to deny the protection order and dismiss the petition. Claudine and Raymart opposed this, saying it was not allowed under the rules. The next day, May 24th, the presiding judge at that time, Judge Bayani Vargas, issued a temporary protection order in favor of Claudine and Raymart and asked the Tulfo brothers to respond. In his response, Ben Tulfo said he didn't make any real threats. He was just strongly defending his brother. Thus, on June 29, 2012, Judge Vargas declared that the case was ready for decision. But before he could decide, he retired on July 11, 2012. Judge Maria Filomena Singh then took over as the acting presiding judge and handled the case moving forward. On August 6, 2012, Judge Singh dismissed the petition filed by Claudine and Raymart and lifted the temporary protection order. She explained that the writ of amparo is only meant for cases involving extrajudicial killings or enforced disappearances, not for threats or harassment like in this case. The judge also said that while motions to dismiss are generally not allowed under the amparo rules, the court still has the power to dismiss a case early if it clearly doesn't qualify for that kind of protection. This helps avoid wasting everyone's time and effort on a case that doesn't fit the purpose of the law. Claudine and Raymart tried to appeal the decision by filing a motion for reconsideration, but the court denied it on January 7, 2013. That's why they brought the case to a higher court. The main issue in this case is whether or not the RTC's dismissal of the petition for the writ of amparo filed by Claudine and Raymart was correct. The Supreme Court rejected the petition, saying it had no legal basis. In the case of Secretary of National Defense versus Manalo, the court already made it clear that the writ of amparo is meant only for very serious situations, extrajudicial killings and enforced disappearances, or real threats of those things. While amparo means protection in Spanish, and it's a special legal remedy to defend constitutional rights, it doesn't cover everything. In the Manalo case, the court explained where the writ started in Mexico in the 1800s. Inspired by U.S. ideas on protecting rights through the courts, a Mexican judge named Manuel Rejon helped include a rule in their constitution that allowed courts to protect people's rights when abused by the government. This became the basis for the writ of amparo. From there, the writ spread to many countries in Latin America. Over time, different versions developed. In many countries with military dictatorships, the writ of amparo became a tool to fight human rights abuses. Some nations used it broadly to cover many rights, while others, like Colombia, Chile, Germany, and Spain, chose to limit it to certain fundamental rights. But in the Philippines, our version of the writ of amparo is much narrower. It is currently used only in cases involving extralegal killings and enforced disappearances, not for cases like this that only involves threats. In the Philippines, the writ of amparo is a special legal remedy that is only meant for very serious cases, specifically extrajudicial killings and enforced disappearances, or credible threats of these acts. Extrajudicial killings are those committed without any legal process, meaning the person is killed without a trial, a warrant, or any court proceeding. On the other hand, enforced disappearances happen when someone is arrested or abducted by the government or with the government's support or approval, and then the authorities deny the arrest ever happened or refuse to say where the person is. The goal is to remove that person from the protection of the law for a long period of time. In the case of NAIA vs. Pardico, the Supreme Court made it clear that anyone filing a petition for a writ of amparo must present strong evidence showing that the government was involved in the disappearance. The same rule applies to extrajudicial killings. Simply put, the petitioner in an amparo case has the burden of proving by substantial evidence the indispensable element of government participation. Notably, the same requirement of government participation should also apply to extra-legal killings, considering that the writ of amparo was, according to then Chief Justice Renato S. Puno, intended to hold public authorities, those who took their oath to defend the Constitution and enforce our laws, to a high standard of official conduct and hold them accountable to our people. In this light, the sovereign Filipino people should be assured that if their rights to life and liberty are threatened or violated, they will find vindication in our courts of justice. Stated differently, the writ of amparo is an extraordinary remedy that is meant to balance out the government's incredible power in order to curtail human rights abuses on its end. Finally, the writ of amparo is clearly meant only for cases involving extrajudicial killings and enforced disappearances, or serious threats of those crimes. This is based on Section 1 of the Supreme Court's Special Rule AM number 07-9-12-SC, which says that the writ is a legal remedy available to anyone whose right to life, liberty, or security is violated or threatened by unlawful actions, whether by government officials or even private individuals. However, it also specifically states that the writ applies only to extra-legal killings and enforced disappearances. While the first part of the rule sounds broad, the second part narrows it down, making it clear that the rule is meant only for extreme situations like killings or disappearances connected to human rights abuses. Both parts of the rule must be read together to fully understand its meaning. Courts are expected to interpret the rule in a way that respects its full context and purpose.